We're going to shift gears a little bit. We're going to be focusing more directly, we think, on the legal consequences of Plata versus Brown and AB 109. And we have three distinguished speakers. I'm going to ask them, even though two of them are attorneys, if they could limit their remarks, to no more than 10 minutes. And you have their bios in your program. Michael Bean is a partner at Rosen, Bean, Galvan, and Grunfeld firm in San Francisco. Jakada Imani is executive director of the Ella Baker Center for Human Rights and a bunch of other things that you can read about. Ahilan, Arulanantham, sorry, I tried to do the best I could with that. Deputy Legal Director of the ACLU. And all three of these gentlemen are, I think, extremely familiar with not only the legal, but some of the programmatic issues that involve trying to reform prison populations, prison conditions. I would like for them to somehow, in their remarks, touch back on the issue of immigration policy and how you think that this interacts with your efforts dealing with the prison system in particular here and jail systems in California. And so Michael, we'll begin with you. You're welcome to stand here or speak from where you're sitting.
Thanks. Good afternoon, good morning, late morning. I'm going to try to explain in a few short moments the more than 20 some odd years of litigation that resulted in the Supreme Court decision affirming the overcrowding ruling last year, which is, as Jim has explained, is the major impetus for realignment to reduce prison overcrowding in California. I think the best connection here, and the reason I think I was invited, is to talk about the pluses and minuses of litigation strategy as a way of dealing with the problems with immigration detention. Is it good or bad? How long does it take? What are the negative and positive side effects, and what are the elements necessary? On October 1st, 2011, as you've heard, major changes in California criminal law and practice, referred to as realignment, went into effect. Within months, these changes, on top of earlier measures, brought the level of overcrowding of California's prisons down from over 200% of design capacity in 2006 to about 150% of design capacity last week, a reduction of approximately 40,000 prisoners. By June, the court order requires reduction to 137.5%, an additional substantial reduction. Whether that happens or not may require further political pressure and further litigation. This critical reform, and we hope the remedy for ongoing constitutional violations in the California prison system, is finally moving forward 6 years after plaintiffs' counsel began the process and more than 20 years after we filed the Coleman class action to provide minimal levels of health care to California prisoners with serious mental illness. For more than 25 years, we have devoted a substantial portion of our practice to representation of persons incarcerated in the California criminal justice system or on parole. Our cases focused on the most basic and fundamental human and constitutional rights. And we relied on the bravery of federal judges who serve for life to listen to the evidence, apply the law, and issue orders. We and these judges ignored the media and the politicians who regularly derided us and them for coddling prisoners who clearly deserved whatever suffering they were receiving at the hands of our criminal justice system. We focused on the most vulnerable and dependent of the prison population, bringing actions on behalf of female prisoners raped and sexually assaulted by guards and staff, prisoners with HIV and developmental disabilities, prisoners who are blind, deaf, or wheelchair riders, juveniles, and our largest case, Coleman, on behalf of the mentally ill. One of the primary lessons we have learned over several decades of litigation, however, is that it's not enough to win your case in federal court. You must also win your case in the court of public opinion. You must not only win a judgment or a settlement, but also change attitudes, address fears and ignorance, and take into account biases and prejudices and realities that have little or no legal consequence to your case, but are outcome determinative in achieving any meaningful remedy for your clients. Winning a judgment or obtaining a settlement in litigation, though difficult, can be the most straightforward part of the case. Turning the judgment into a meaningful remedy is far more challenging. In Coleman, the complexities of designing and implementing a mental health delivery system and a state prison system were enormous. The case was filed in 1990 on behalf of all California prisoners with serious mental illness. After extensive discovery and more than 30 days of trial, the federal court entered a judgment in 1995, finding that the state's prison system was violating the 8th and 14th Amendments of the Constitution by failing to identify and provide treatment for the thousands of mentally ill prisoners in the system. The court ordered the appointment of a special master, and we began the remedial phase of the litigation. Over the next 10 years, we worked together with the special master and experts to develop policies and procedures and standards for a mental health delivery system. Numerous obstacles and barriers emerged, each posing unique and sometimes insurmountable challenges. Many prisons were built in remote parts of the state, making recruiting and retention of sufficient mental health clinicians, especially psychiatrists, a constant struggle. Court orders for special bonuses and even across the board large salary increases have only been moderately effective. Timely access to higher levels of care was hindered by security issues and shortages of beds. Plans to address each deficiency were developed and approved, but progress was slow and frustrating. By 2006, it was apparent that extreme overcrowding in the California prison system, the elephant in the room, had to be addressed head-on. A federal law passed in 1995, the Prison Litigation Reform Act, had taken the tool of population caps and limits away from federal courts in prison and jail reform litigation. The procedural hurdles established by the law appeared insurmountable. But when Governor Schwarzenegger himself declared a state of emergency in the California prison system due to overcrowding, we decided that we had to move forward and directly seek a population reduction. The state of emergency proclamation by Governor Schwarzenegger was our trial exhibit number 1. As a result of extreme levels of overcrowding, the healthcare system was backsliding, getting worse. The suicide rate in California prisons remained far above the national average. The prevalence and acuity of mental illness in the prison population was steadily increasing. 1 in 4 California prisoners was identified as requiring mental health care, and the demand for higher levels of care was markedly increasing. Wait lists of hundreds of patients requiring inpatient psychiatric hospitalization backed up the system. Prison wardens and clinical staff housed psychotic patients in makeshift locations, holding cells and segregation units, unable to access the already full mental health units. Overcrowding causes a toxic cycle. All available recreation and programming space have been turned into dorms, gyms, day rooms, even hallways. First, prisoners were double bunked, then they were triple bunked. Then basic functions such as toilets and showers and sinks constantly broke down. Stress and violence increased. Lockdowns, the cancellation for weeks or months of all programming, including healthcare and exercise, were the custody tool to control the violence. Rehabilitation was out the window. Teachers and drug counselors were laid off because of a lack of money, lack of space, and a lack of will. The overcrowded conditions increased the demand for mental health services at the same time that overcrowding itself limited the system's ability to expand the supply of services. Delayed access to mental health care made the bad situation even worse. Prisoners who may not have even required mental health services to function now required help. Prisoners living with a major mental illness became much more acutely ill. While our prior prisoner rights cases addressed conditions of confinement inside of the prisons, the overcrowding case required us to prove not only that overcrowding was the primary cause of the ongoing constitutional violations in the prison system, but that the prison population can be reduced without, quote, and adverse impact on public safety. The law also allowed public officials to hire lawyers and participate in the case so long as they opposed our efforts to reduce overcrowding in the prisons. More than 140 Republican state legislators, district attorneys, sheriffs, chiefs of probation, and even 6 counties joined in against the prisoners. They argued that any reduction in the prison populations would be disastrous for their communities. Crime would increase, local resources for drug treatment and mental health services would be overwhelmed, county jails would become overcrowded. Biases and prejudices against the Coleman class, the mentally ill, emerged front and center. The mentally ill were too dangerous to be included in any prison release, the court was told. No matter how bad things were in the prisons, keep the mentally ill in the prisons. The conservative, tough on crime prisoner guards union, much to our surprise, joined the prisoners in advocating for a population reduction. Life inside the overcrowded prisons was dangerous not only for the prisoners, but for the custody officers. We had no choice but to engage in the debate and prove both to the 3-judge court and to the public not only that the prison conditions were so bad that this extraordinary remedy was necessary and appropriate, but also the more difficult point. There were safe and appropriate methods to reduce the prison population over time. There was nothing to fear, even from the mentally ill. In 2007 and 2008, we reopened full-scale discovery of the California prisons in preparation for a second Coleman trial, this time focused on overcrowding. The trial concluded in early 2009. With the help of experts in criminal justice and mental health issues, as well as the most conservative and respected correctional experts in the country, including Jim Austin, we were able to demonstrate the extraordinary and unprecedented dangerous level of overcrowding, the ongoing constitutional violations. We also addressed the unique and dysfunctional aspects of California's criminal justice system that both contributed to overcrowding and undermined public safety. In the midst of the overcrowding case, California went from a major budget surplus, I don't know if you guys remember that, but just a few years ago we had tens of billions of dollars of surplus, to a financial crisis. Suddenly money became an issue, and we introduced evidence that many states, New York, Georgia, Florida, Kansas, Texas, had adopted smart on crime policies that saved money, reduced crowding, and improved public safety. In August 2009, the special 3-judge court ruled in our favor, ordering the state to reduce the prison population over a 2-year period by approximately 40,000 prisoners. The court found that there are many available methods to safely reduce overcrowding in the prison system, and the result should be an improvement in public safety and large savings in public spending. The court also found that the existing overcrowding prison system was criminogenic. It tended to worsen public safety because of the absence of rehabilitation programs and the mixing of low-level technical parole violators with violent, hardcore prisoners. The Eighth Amendment prohibition on cruel and unusual punishment has been interpreted to also require prisons to provide basic mental health care and medical care. But at least 2, and probably 4 Supreme Court justices have already expressed their disagreement with this view based on the doctrine of original intent. In their view, the Eighth Amendment only prohibits forms of torture. It does not require health care. Going to the Supreme Court risks not only the loss of whatever benefit we'd gain for our clients, but also could set back prison reform law for the whole country. We spent a long time trying to settle the case, but we ended up having to defend it in the Supreme Court. On May 23rd of 2011, the Supreme Court in a 5-4 decision ruled in our favor. We dodged the bullet and ended up with a positive and powerful decision in a term with many black marks for civil rights. Justice Scalia in dissent called the lower court's order the most radical injunction issued by a court in our nation's history. Justice Alito accused the majority of gambling with the safety of the people of California. Justice Kennedy's decision is a powerful affirmation of the fundamental power and duty of the federal courts to remedy violations of constitutional rights. The Eighth Amendment not only lives on, but it's stronger. I've come to appreciate that perhaps the most powerful tool of persuasion, not only for the media and the public, but even for hardened judges, are photographs and videos. I actually brought some here today. I don't know if we have time to do quick.
Quickly.
Quick. Okay.
So I set up for you.
That's up,
Just
okay.
scroll down. There you go.
So I'm going to skip through. These are dorms, triple bunked. This is mental health care in a cage. This is group therapy. This picture, the Supreme Court actually attached to its decision 3 of our pictures, very unusual, but in the official reports. That's a place for suicidal prisoner. Most don't have beds. One of my clients. These are holding cells. Another presentation, I just point out that Abu Ghraib was in the news for years. No one did anything, right? Then these pictures came out, and the world changed. And that's the same reason we think that when you're working on these issues, people react to photos and videos much more than they do to information. And policies can only change if you reach people, and even the judges reacted very, very strongly to the photos as much as they did to the evidence. Thank you. Do you guys turn this off, or
Might want to leave it on.
you want to leave it on?
No, wow, thank you for the help. So, I'm Jakada Imani. I'm the executive director of the Ella Baker Center for Human Rights. The Ella Baker Center is named after an unsung hero of the civil rights movement who inspired and guided emerging leaders, and we try to keep our legacy alive by giving people the skills and the opportunities to work together to strengthen our communities so we all can thrive. For the last, an organizer on our staff had started organizing families of incarcerated youth around the Bay Area, and found that the families who told the most horror stories and who were the mothers who were most impassioned to fight were parents and family members of children who'd ended up in California's abusive youth prison system called the California Youth Authority at the time, now the Division of Juvenile Justice. And so we started organizing these parents. The organizer decided to do a film about these people's experience, again, realizing that, moving pictures speak so much more powerful to people and could actually shift the balance of forces. And then all of a sudden, the judge in this case said, I actually am not an expert on juvenile justice, and I won't be able to figure this out. We'll need some experts that you all can agree on who can do an assessment about the system, and that'll be the basis of facts for this case. And so the state and the prison law offices and their co-chairs picked some experts who did a deep study of the system and came back with these incredible reports that said what families have been saying for decades in the state. These places are hellholes. It's no place for young people. They're ridiculously violent. The cages you saw, the people receiving therapy in California's youth prison system at the time, that's where kids went to school. It was a classroom full of cages where students sat in those cages for 4 hours a day receiving, right? So those pictures came out, and we decided to take our campaign full blast. So coming on the heels of this incredible lawsuit by the prison law office that was settled, obviously, once those pictures came out, and the actual neutral observers who were supposed to do all these studies came back and said, this place is ridiculous. It's one of the most violent youth systems in the entire state. Also one of the most expensive. To this day, it's $216,000 per youth per year with a 95% failure rate. Right? So we started organizing families of those incarcerated youth. The state legislature did hearings on it. We brought families to those hearings, packed those hearings, and got people to tell their stories. This kept pushing the system to change. I think for us at the Ella Baker Center, we wanted to close and replace these youth prisons with something that actually worked. We wanted, these things are actually staffed by prison guards, who are the same prison guards who work in the California adult prison system. And we said we wanted a model that was similar to what they've done in the state of Missouri, that is staffed by counselors, teachers, and youth experts. And so we pushed that vision. I think the prison law office had an incredible vision for reforming the system and dealing with the abuses. We leveraged the incredible work they'd done in the courtroom to actually play it out in the court of public opinion. So here, I'm born and raised in this state, came up during the sort of the height of the crack epidemic, came up in the height of the sort of the terror and the fear of the super predators and the brown kids that were gonna run amok, and part of the prison building boom in this state. None of that stuff ever materialized. At this exact moment, when we're supposed to have this sort of runaway youth crime spree, super predators who you have to lock up forever and ever, crime is trending down. Oops, right? So what I think one of the lessons, not only can you campaign off of the incredible work of tremendous attorneys like that we've done with our work, but the other thing that I want to lay out for you all is that this isn't just a legal problem. To some extent, it is a legal problem. There are laws that are on the books and laws that are not on the books that are in our favor or not. But it's also a political and social problem. That our government has made a set of assumptions and political assessments, right? That's very similar to the correction system on the immigration side. Is that there are a whole host of people who are throwaway. And that you can make your name off of being tough on those folks, right? So for us, in California, and I think broadly in the United States, that is predominantly African American Latinos. People talk about crime, and people think about crime, and when you think about letting all these people go out of prison, they're not thinking about Johnny who got a DUI and hit somebody. They're thinking about my brother, my cousin, Jose from around the corner with a tattoo on their back who's gonna be in their front yard doing some stuff they don't want. And so it's deeply, deeply racial. Even when it's wrong, it's deeply, deeply racial. And we have to confront that or you can't get through it. Similar on immigration. It's not the sort of the Irish immigrant who's overstayed their visa that they're thinking about detaining, or the person who came in from Canada to go to school and then flunked out and hasn't gone home. That's not who we're talking about detaining. We're talking about detaining predominantly brown folks, Asian folks, Latinos, African folks. That's who we're talking about detaining, and that's who we're talking about deporting. And so when we talk about immigrants and immigrant detainees, it's a racialized category. And so we have to take that on and think it through in very articulate and powerful ways. And so being able to leverage the legal work of really smart attorneys to force folks to make real changes in their systems, and then for us and other advocates to be able to campaign on top of that, next to that, up and around that. So what we did in our campaign and what we've done is every time there was a hearing or a court date where the state had to come in and release their data, talk about the improvements they've made or the improvements they haven't made more accurately, in general, they don't want to do a press conference, but us with families do. And so we would show up on the steps of the state capitol and do that press conference and talk about what are the alternatives, what are the ways they can actually meet these numbers. One of the things we're actually currently exploring is continuing the campaign around this incredible lawsuit. The state came forward recently and said, we think we may have done enough. And we're not, this getting down to like 137% of capacity. It's not so bad now. People are just now triple bumped and not quadruple bumped. And mostly people are out of the gyms. And so we think it's getting better. And so we're not actually going to release anybody, which they never did, just to be clear, right? They never actually opened the prison gates. You heard David say that earlier, bloated people up on buses and sent them home. They just stopped bringing people into state prison, which then the natural attrition has brought it down. But that means that every law that was ridiculous law that makes you have to serve a ridiculous sentence in the state of California still exists. They just shifted the burden, right? And so what we see, I think what we're beginning to see with ICE is something similar. They're not actually, they're just hiding people and dispersing them throughout the country, and rapidly growing is this private incarceration and private detention. And at the Ella Baker Center, that's something we're also exploring taking on, is in a time when all of our states and our federal government is telling us that we have to make tough decisions, we have tough choices to make, how is it we're setting aside $2 billion of our tax dollars that we could be used for education, roads, job training, you name what you care about, we could spend it on that to incarcerate people who are not a risk to public safety. but hardworking people who came here to create a better life for themselves and their family, hardworking people who came here to join their family who is already here, right? And we're spending our tax dollars so somebody can make a profit off of adding damage to damage and pain to pain, while we have to make tough choices. We say that's not fair and that's not acceptable, and we should do something about it.
Thank you very much.
Hi, I'm Ahilan Arulanantham from the ACLU of Southern California, and I do mostly immigrants' rights and national security litigation against the federal government. First, I should thank UCI for hosting, and thanks very much to Human Rights First for putting this together. The first time I went to an immigration detention center, I was a baby lawyer, and the person who took me was Anwin Hughes, who's a fantastic immigrants' rights and detention advocate for Human Rights First in New York. I'm actually going to talk a little bit, it's a little bit better. Can you all hear me better? I'm going to talk a little bit about the lessons that I've learned from immigration detention litigation over the last 10 years or so, and you know, what that can tell us with respect to how we should approach immigration detention work. So I haven't done prison litigation work at all, so I want to talk about the lessons that you can draw sort of in both directions. I do want to have a sort of a caveat though before I start, which is I think the immigrants' rights movement as a whole and the people who work on immigration detention have a huge amount to learn from the prison reform movement and prison litigators, and as a communication detention by comparative standards. At the same time, though, I think it is very important to remember in our minds, as you were saying, Jakada, so eloquently, right? Immigration detention centers are prisons, right? We know that the civil detention model is a fiction. The Theo Lacey Detention Center is actually just about 10 minutes drive from here. I was seeing a client there just a few months ago, and he was telling me about it. He was in a cell with 2 people. His rep time was limited to a couple of hours, a week, and it was the same conditions exactly that are applied to the criminal detainees who were there. But of course, he didn't get there with a trial, and he had no appointed counsel, which actually was sort of the reason that I was seeing him, and he had no probable cause hearing, and he had no right to a bail hearing, and all these other things. And so I do think that while we have so much to learn from this community, it's also important for us to remember that the ultimate goal, at least in my view, should be either the creation of the same procedural protections that you have in the criminal process, so that the punishment is given the same protection that is required by the Constitution, or the creation of a civil detention system, which I guess we'll hear about later today, but which in my view would be just radically different. I'm not sure what it would look like, but it'd have to be just completely radically different. So it couldn't look anything like those pictures, whereas to me, those look awful. But I remember being certainly in Newark and New York after 9/11, and the Passaic County Jail and Hudson County Jail didn't really look particularly different than that, at least as I can remember it. But in the meanwhile, we can't forego conditions work, obviously, while we wait for the revolution. So let me give you a few lessons. I think the most formative case for me in thinking about detention litigation is a case called Rutherford v. Pitchess. And I'm curious to know how many people here have even heard of Rutherford v. Pitchess, right? Yes, the people who do conditions work on the criminal side have heard of it, the immigrants' rights people have not. I never worked on Rutherford v. Pitchess, but it was a fairly comprehensive conditions lawsuit filed against the LA County Jail, which is, as I understand, the largest jail in the country, in 1975. And the story is a little bit like Michael Bean's story. Went to trial and won permanent injunction, the gold standard of relief, in 1979. Went to the Supreme Court. Some of the injunction was lifted, but much of it remained in place. And in particular, the parts that I know well, floor sleeping was banned, except for a very, very limited exception. Contact visits, outdoor recreation, TVs, various other things required. When I came to the ACLU in Southern California in 2004, all of those problems were alive and well in the county jail. The floor sleeping, there was a sort of an outbreak of massive floor sleeping problems. You know, at some point in 2006 and 2007 when I was there, outdoor recreation remains a serious problem in the jail. I'm not an expert, and I think probably several people here know more about it than I do, so I'll stop at that, except to say, you know, the lesson I learned from sitting next to the people and hearing their discussions of Rutherford in the course of our legal meetings was you have to be very cautious about conditions litigation. You have to have the resources. You know, if you can hire, you know, Michael Bean, and you know you can spend the time and the resources to take on systemic problems in a detention center, then go for it. I actually think it's very important for us to do what we do in the LA County Jail because it is the largest jail. It's right in our backyard, and the problems there are very serious. So I would not say that we shouldn't be doing that. But the question is, do you have the resources? Easy to find violations, right? And harder, but you know, still, you know, not the whole story by any means to win it. To prove the violations. You know, that's when the work starts when it comes to conditions litigation, is after you've won that injunction or won that consent decree, and do you have the resources to monitor it? You know, and then in particular, and this is a lesson that I think I've learned more than any other through this, what will the order say? If you want to bring a court case, at the end of the day, you're going to get a piece of paper signed by a judge if everything goes well. And what will that order say? If the order has to say something like, don't be sadistic to the prisoners, right, then it's obviously not going to be just the order which is going to fix that, right? Because the people who are engaged in endemic violence in the LA County Jail, which is a massive problem, probably aren't going to change their behavior because the judge signs an order that says that. And then, of course, with immigration, we've got the overlay of the fact that the ability to move plaintiffs, the DHS's ability to move plaintiffs, which is, I know, is an issue in prison litigation as well, it sort of takes on another level, right? Because immigration detainees, of course, are transferred back and forth around the country with great ease and really no significant constraints. So, for example, you know, the San Pedro Detention Center several years ago was closed virtually overnight after having been here for a long time. The Miraloma Detention Center, which at one point was the largest immigration detention center in California, was closed. They announced that it was going to be closed and is going to be closed very shortly. So we have to have those things in mind. Now that doesn't mean that you don't do it, and so this sort of gets to the second half of what I was going to say. But a lot of the problems that we have heard about, and some of them have been quite severe over the last 8 years or so here, medical complaints, use of force issues, coercion of various kinds, our approach has been, even more than in other contexts, to first see, is there a way we can do this through advocacy? Is there a way we can do this to help this individual out, or to help this set of people out? Meet with ICE. You know, my normal view is you can have two kinds of meetings, one where you have sued and one where you haven't sued. You know, and they're very different, and usually the first kind is better. But when it comes to conditions, it's not necessarily the right approach to take because, you know, for all the reasons that I've said, it's often perhaps a better way to approach it to meet with ICE. That being said, those things often don't work, and then you have the hard question of what you should do about it. So I wanted to talk about two cases very briefly that we've worked on in the past. In 2007 and then in 2008, we started getting a regular intake from a place called B18, which is the holding cell in downtown Los Angeles below the immigration courthouse. And it's actually, people don't think of it, but it's actually a pretty large detention center in that it holds several hundred people on any given day. But it only holds those people, well, it's supposed to only hold them for something like 12 to 24 hours. And it's a processing center. We got an intake that people were being held there for weeks and in some cases for months. In this place, there were people sleeping absolutely on the floor, just there's no beds in there, so just sleeping on the floor. Or they were being sent to little local jails, tiny little local jails like Alhambra and Pasadena and places like that in the night, and then brought back the next day, sent, you know, the shuttling process for weeks or for months. No showers, no toothbrushes, certainly no access to legal materials, pencils, pens, etc. We chose to bring a lawsuit against that because it's very difficult to move that place because it's below the immigration courthouse, right? So it's very, very hard to do it. And then second of all, we chose to sue it because you could basically fix the problem by requiring the government to only hold people there for something like 24 hours a day. And so although to make the place lawful under sort of normal detention center standards, you'd have to put in showers and toothbrushes and legal materials and, you know, all these other things that, of course, it was not equipped to do, which would require a huge amount of, basically an overhaul of the place, and we didn't think that was possible, and didn't think a judge would order it. You could much more easily require them to say, okay, change the system, fix the administrative glitch in your processing, and get people out of there very quickly. Now, I should say, you know, in hindsight, it worked out really well. We filed the lawsuit before anything happened, even a motion to dismiss. They changed that and fixed it. It's worth noting, I think, that even when we did that, we weren't totally sure as to why the problem was happening. And that gave us some amount of pause. In the end, it worked out okay. I actually think it's also important to remember before you do conditions litigation to know why is it that this is going on, you know. Other case I'll just touch on very, very briefly, and maybe we can talk about it afterward a little longer, is Rodriguez v. Hayes, which is part of a set of cases that we had brought. Actually, it's 3 class actions and probably about a dozen individual cases that we had brought over the course of the last 8 years, challenging the government's policy of holding people without giving them bond hearings. You know, I was saying at the beginning, the importance of trying to create some of the basic procedural protections that exist in the criminal system on the immigration side. I mean, this is sort of like the most basic of the most basic, just the right to ask for bond. And as people know, most people in the room, mandatory detainees, which include a lot of low-level offenders, asylum seekers, and various other classes of people don't have the right to ask for bond in front of an immigration judge just to get that bond hearing. There, too, it was very difficult at the beginning because of mootness problems. So, you know, when you filed individual habeas petitions, you know, after you won a couple, then the government starts releasing people and thereby prevents the creation of law that allows you to actually change the system. Then when we filed the class action, then their behavior changed. And actually, after we filed the class action, it was possible to litigate individual cases because the government wasn't so interested in moving them out anymore because they knew the class action was sitting there. And that too, it remains to be seen if you know, where it'll end. But at the moment, we've had, you know, very good luck making change in the amount of detention that exists within the Ninth Circuit. In particular, people detained for very long periods of time, that has dramatically decreased throughout the circuit because of some of that litigation. So I'll close up with just a couple of these lessons that I think is important to remember. You know, first, litigation is only one tool. So if there's a way to do it by advocacy, you know, both at a systemic level, and then also even if, you know, you're just a litigator and all you do is sit in your office and litigate, still think about it. Is that really the right approach to take with respect to this particular conditions problem? Now, second of all, is there a procedural fix? You know, why is this happening? What's the nature of the problem? Is it something that can be fixed relatively easily in the administrative system? Is there a cost issue? Or is it something that is the product of state laws and social forces that are kind of driving the system, you know, in a massive, massive way, so you know you're not going to be able to fix it. You know, they're not going to be able to fix it to settle your suit in a relatively easy way. You know, and then of course the third issue is what's the likelihood that you will have the resources and the location to continue to do this over time. So we have, you know, in addition to the D18, the ACLU has sued the San Diego Correctional Facility for crowding and for medical care, you know, several years ago. That was again a decision made because we believed that ICE wasn't going to close down the San Diego Detention Center for immigrants, you know, because it was right next to the border and you know, that kind of condition. So those are some of the tactics that I think I've learned from the time I've been doing this.
Thank you. All right, so we have some minutes for some questions. So if people have some questions, you can work their way up here. I have a couple that, and I'm going to start. Is there a constitutional issue here? You talk about the conditions of confinement, but I'm looking at a different angle, which is that the action of detention is not proportional to the harm, potential harm. So, for example, dangerousness. And I don't know if as an attorney, do you see any angle? I think it could be demonstrated pretty easily from a scientific point of view that these people pose very little risk in terms of public safety. So I'd like to, if you don't know if you thought about that, rather than pursuing conditions of confinement, can you also pursue something else that would have to do?
I'm going to throw it to him.
I mean, the law is very clear that immigration detention is civil. So proportionality analysis doesn't even come into play because it's not punishment. Right. So actually, I think that the two ways then you get there are these conditions punitive? Can you show that particular
What
conditions?
what is the basis, so if it's civil, like, you know, in civil actions, we don't see incarceration used too much?
Not true, not true. I mean, I think the framers would be pretty surprised if you told them that there are sane people who were not caught on a battlefield, who were jailed in this place, 10 minutes from here, and they never got a trial, and they never saw a jury, and, all the rest of it. But, for about, originally it started as incident to deportation, the idea that, well, you have to detain the person right before you send them out of the country. And then if they won't show up, then you have to detain them for longer. And that was basically the justification. Just like you can detain someone before trial because they're a flight risk, you can, that was the argument. Now I don't think that when they wrote that, I mean, that law is very old. They imagined 33,000 people, many of whom stay in detention for years, and many of whom were ultimately going to win their cases.
But let me ask you, and you guys can jump in, because Jakada mentioned, that going back in time, I know we detained Japanese, World War II. Is there any precedent for this large number of illegal immigrants being detained? What was the practice, let's say, prior to the 1990s or something like that?
It was something like 3,000 to 5,000, I think, prior to 1996.
So was this the common practice, if you were illegal, that the presumption would be detention?
I don't know about the presumption, but there was immigration detention going back a long ways. But it was, like I said, generally shorter in time, generally restricted to a certain class of people. But there were other spikes in the 50s during the Red Scare and the anarchist movement. Yeah, go ahead.
Michael, and then I'll get to Jakada.
I guess the only thing I don't have the historical information. I just would argue that there is a constitutional argument, at least, under the due process clause, just to say that if we're taking away your liberty, you're entitled to some basic process, not the full criminal trial, not everything, but under Matthews v. Eldridge, a Supreme Court case, and others that still exists, we've used that case to build the rights of parolees to have good parole revocation hearings, including counsel for many of them. And it's something that I think we should work on with the immigration community. We derived a right to counsel, and California actually made it 100%, by pointing out all the people who everyone would agree would need counsel. So for example, non-English speakers, people with developmental disabilities, people who are mentally ill. Keep the list going, and pretty soon you have 50, 60, 70%, and then the process for picking out the people who needed counsel was more expensive than providing lawyers. Lawyers are actually very inexpensive. And the system in California for parole was 100,000 parole proceedings a year. Lawyers were appointed within 3 days for each person, never late, and they were paid $200 a case. People made good livings doing that. Unfortunately, just part of realignment is that we're doing away with that system. But it's an interesting model. There are a lot of lawyers on a contract basis that could do these things and do it inexpensively, not public employees, nothing against public employees, but no benefits, no nothing. But, and again, the point was that you have to give some basic process to a child who's disciplined in school, some process. Certainly someone who's being, you can call it civil detention, but they're still being locked up and not able to be with their family or work or do anything. They're entitled to substantial process.
My analogy, on juvenile justice, we had status offenders, and status offenders were incarcerated until we had a movement which says, well, the presumption was not to incarcerate juveniles, because it wasn't criminal. So I just was wondering, is there something here that rings a bell?
Yeah, I mean, the cases limiting prolonged detention have generally gone on the procedural due process kind of model. I'm curious to know from what you said, Michael, did you first establish the right to people who didn't speak English and who were mentally ill, etc., to a right to counsel, and then move to get the system to figure out who those people were, or did you do it all in one packet?
Well, first of all, there was a Supreme Court case from the 70s that had said that in these kind of proceedings, parole or probation revocation, I assume they apply to Department of
They
Justice
do.
too. And effective communication is required for equally effective communication, sign language interpreters, hearing, all these kind of things. So we've kind of mushed together the ADA and Rehab Act requirements and due process and ended up with a tremendous percentage of people in California in the criminal justice system who would require counsel under anyone's standards. And they finally said, it's easier to appoint 100% counsel than it is to try to figure out the 5 or 10% that don't need lawyers if you really fairly did it.
Okay. Shift gears. Now, there's other models for change, and you were talking about public advocacy, but I think also in the case of the California Youth Authority, there was also an economic model, right, that was employed. And for those of you that are below our age group, there's the old California probation subsidy program where basically counties were paid to keep their numbers in terms of commitments to state prison. There actually was an experiment in the California prison system where they paid the parole officers, gave them additional resources if they didn't violate so many people, which temporarily reduced the population. California Youth Authority has been reduced dramatically, right? And it's an economic model, right, where they actually pay. Do you see, could you comment on that, and then also comment how this might apply in any way, shape, or form to immigration policy?
Yeah, I can address that. I also want to say that I think attorneys in the immigration system may look at the criminal justice system and say, ooh, we'd like to have some of that. I just want to caution you, as somebody who spent a lot of time in the criminal justice system or working with the criminal justice system, it's not mostly good, it's mostly bad, and it mostly doesn't work out well for people. And so really think about what it looks good in the smorgasbord, but then you get it on your plate and it tastes really horrible.
I agree.
Yeah, so I think, so in the California Youth Authority, I think there are a couple different drivers to reducing placements there.
Which it went down dramatically, from like, it used to be at 9,000.
Yeah, it used to be 9,000, then it was 4,500, and when the prison law office launched their lawsuit and we launched our campaign, it's now got down to, I want to say 900 young people in the state.
So that's pretty dramatic.
That's huge. It's huge. And so I think there are a couple different things. One is that they made getting from 9,000 to 5,000, a big jump was that counties had to pay a part of the freight. That you had to figure out sort of like, what are people in there for? And if it's not above a certain level of offense, we're not going to keep it. You can't send them to state facility. If you do, we're going to charge you. And then they did something very similar to what they just did on the adult side, which is they just sort of said, if you fall into these if you don't have a serious offense or a serious history of criminal involvement, we're not going to accept you at all. Even if you pay, we won't take you. And then that made a huge dip in how many young people went into the system. I think one of the arguments we made, and it's in our Frank Books Not Bars, was that there's a trade-off, right? That for everybody we send to prison in this state, that we then can't send a young person to school, or we have to crowd more of them into a classroom, or we have to furlough more people at the DMV, or roll back fire services to some rural community. That there's trade-offs. That this is a zero-sum game. There's only so much money. And I think that there is an argument to be made around immigration detention, around it. I think the other thing is that this is clearly not about somebody being a risk. And here's the thing that Jim showed you, that beautiful slide that I want to get a copy of. Incarceration isn't about crime. Prisons are not about crime. Immigration detention isn't about risk. And so if you speak inside that frame and you get trapped inside that frame, they got you, right? And so here's one of the interesting things about getting attorneys for everybody who's detained in the immigration system. Who's going to pay for it? We're going to pay for it. Do we want to pay for that? Well, we do. But the grand we in this country, do we want to pay for people who are here without documents? Some might say illegally. Do we want to pay for those people to have attorneys to decide whether or not they get to stay in the state or the country? No, we don't. And so therefore, should we want to pay to lock them up while we determine? No, we shouldn't, but we do. So I would push it the other way. I wouldn't push for more stuff inside the system to make the system work more efficiently and effectively. Why? It's screwed up and it's horrible on its face. Let's not, and that's been part of the challenge with all the wonderful work done of corrections reform, is that it's widened the net, right? Like, roll the tape back and it's like, we used to hang people. That was it. You got caught doing something, you got hung. And then we were like, you know what, that's not that good. There's certain stuff we shouldn't hang you for, so we're gonna have these penitentiaries where people go and they pay, right? And then if you look at how people got locked up, that was more people than we ever hung. And then we came up with every reform to some extent has been, and in some ways, a net widening effect, right? And we just heard that conversation earlier about like, now there's alternatives to detention, and so people who would never be detained, people who would just be like, that's silly, don't do it again, go home, now end up in a program that if they fail out of that program, they get locked in a cage. So if we actually get people to attorneys and we start making the system function, then the system works. But the thing is, it doesn't work. So we should just shut it down. We should like grind it to a halt, right? Go the other way. You want to shrink it, right? So I think, I'm for starting a movement for, we're going to end detention because we're going to take the money out of detaining people. And if there's no budget to detain people, then how do they do it? Right? You heard what Santa Clara said was, if you asking me to pay for it, I'm not going to do it. But if they can't enter into contracts with local communities or with private industry to do it, then where do they lock people up at? The United States government's going to build prisons? We can't build roads, and all of us use roads. Right? So I think let's flip the thinking about what direction we want to go.
All right, thank you very, very much. And so we need a shrink ray gun, that's what we need.
Yes, honey, I shrunk the
All right, I'd like to thank our three panelists. We break for lunch. Any instructions on where to go for lunch?
Lunch